Just want to go.
Okay, now it says it's being live streamed.
Yeah, it's still uploading on my end.
Okay, now it says it's being live streamed.
Okay, yeah, it's still uploading on my end.
The patient was 6 years put in mind. So 5 years put in June. 6 years, 6 years TDC. They goes to negotiate. Yeah. So so we'll go over the paperwork. So you have to this meeting activity.
Okay, so I'm gonna log off and I hope it keeps you with the thing, okay?
Okay.
Yeah, so it'll come out of the out by April. So this allegation. It's automatically a 30. Okay. That's good. So, so it's all the back up here. We'll go back to the so it means 6 years, but it's probated for 5 years. 5 years. So this is all just going to be done. Go over the age. It's the same. That's the same. We see it. Okay. Understandable. This is the same. They're confessing to it. They're saying to the side. So these are all the Either way, so we have so Sorry. It's like a driving an 82 thing. Yes. Yeah. I mean, yeah, basically. No.
Deputy Everett,
Maybe from upstairs. My name's on the caller ID upstairs.
hey Deputy Everett,
That'd be from Teddy's phone upstairs. Yeah, extension 384. Yeah.
Mr. Schmidt,
Yeah,
is Miss Lee out there, Shonda Lee?
I haven't seen her yet.
Okay, all right. I was just checking. She has an inmate zooming from Smith County, so they're ready to go. I didn't know she was there. So, all right, Mr. Schmidt, are you ready?
Judge,
Okay, I'm ready.
Judge, just for the court's information, I spoke with Miss Lee and I believe she said she would be zooming in. So we probably need to look for her in the online waiting room.
All right. When she logs in, I'll let you know.
Thank you, Your Honor.
Mr. Schmidt, who are you ready on?
I'm ready on Mr. Toll and Mr. Gurley.
All right, let's see here. Ronald Toll, CR 21-146, CR 22-297, motion to revoke and pretrial.
Judge, on pretrial, we don't have any contested pretrial motions at this point. Ask that be separate docket call. Ask that the motion to revoke be carried with it.
All right, court will set CR 22-297 for docket call. You want to set that on that 13th date, Mr. Schmidt?
Yes, sir.
All right, court sets Mr. Toll then for docket call on December 13th, and we'll carry the motion to revoke same date. It'll be at 1:30. All right, Mr. Gurley. All right, Mr. Schmidt, I believe that we're set for pretrial.
We are, Judge. I went to the DA's office last week in hopes of viewing the evidence. We had some technical difficulties, I think, and Well, I had to leave without being able to actually go through it. Hopefully we get that done either this week or early next week, but from that perspective, I'm gonna ask for an additional pretrial. And Mr. Gurley had an opportunity to look at the forensic evidence. I think it's ready. Just I couldn't get my hands on it.
Okay. Do you want to set on that same December date, or do you want to set it sooner?
I think that December date's fine. Judge.
Okay. All right, court will set all of Mr. Gurley's cases on Tuesday, December 13th. Also for pretrial. You ready on any others, Mr. Schmidt?
No, that's all. I got females coming, but all these are males, so whoever's next.
Your
Mr.
Honor, I'm
Wilson?
Sean Murphy. It's a plea.
All right. Sean Murphy, CR 22-337, 2022-349. I show that Mr. Murphy is set for arraignment in the continuous violence against the family case and pretrial and the other. I also have a notation that we may be pleading the case today.
We are pleading the case today, Your Honor. I just finished going over the paperwork with him.
Okay, can you tell me the terms of the plea, Mr. Wilson?
It is a plea of guilty. It is going to be 6 for 5 on the felony with a $2,500 fine and a 1245 of the misdemeanor.
1245 of the misdemeanor criminal mischief.
Yes, Your Honor.
Court cost $290.
Yes, Your Honor. Reimbursement of $895.
$895 reimbursement. Any weapon forfeitures or anything of that nature?
No, Your Honor.
All right, Mr. Murphy, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Sean, is it Padraic Murphy?
Yes, sir.
And Mr. Murphy, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Bipolar.
Are you currently undergoing any type of treatment or on medication for bipolar?
On medication.
All right. Do you feel like you have a rational understanding of the proceedings as they are going on here today?
Yes, sir.
Okay, very well. And in this case, you're represented by your attorney, Mr. Wilson. Are you pleased with Mr. Wilson's representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Anything about this paperwork that you've read over and signed with Mr. Wilson that you do not understand?
No, sir.
Mr. Wilson, do you believe Mr. Murphy to be competent today?
Yes, Your Honor.
And you've explained to him his legal rights as they pertain to these cases?
Yes, Your Honor.
Mr. Murphy, you've heard Mr. Wilson tell the court what the plea agreement is. Is that your understanding of the plea agreement in this case?
Yes, sir.
And that's what you're asking the court to approve?
Yes, sir.
All right, Mr. Murphy, I must admonish you that the range of punishment for a third-degree felony offense of continuous violence against the family, if convicted and sentenced, it would have to be within the range of not less than 2 years in prison or more than 10 years in prison, and an optional fine not to exceed $10,000. I find here that the proposed plea agreement would legally fit within that range of punishment. So with that understanding, then I would ask you, Mr. Murphy, how do you plead to continuous violence against the family, a third-degree felony?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Mr. Murphy, has anyone threatened you, forced you, or pressured you to make you feel like you had to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Wilson, any objection to the state's evidence?
No objection, Your Honor.
All right, state's evidence and the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, I am looking, victim notification. We are in compliance, however, have not received anything from the victim.
Thank you, Ms. Heisel. Can you go ahead and give me the facts to support the plea?
Yes, Your Honor. Judge, in February of this year, Mr. Murphy's girlfriend comes into the sheriff's office who has a visibly red, swollen, bruised face and said that he assaulted her. The sheriff's office essentially goes out to their residence to attempt to get his side of the story, and he immediately becomes combative when they approach him. So they do place him under arrest for assault, family violence. Then additionally, in July of this year, again, they're dispatched out to that same address. The victim at that time is pretty non-cooperative with law enforcement. But there is an eyewitness who I believe is a next door neighbor who states that she saw the entire exchange and that she sees Mr. Murphy pushing the victim, grabbing her by her hair and spitting in her face. Your Honor, the criminal mischief that is being 1245 into this also arises out of this relationship. Essentially, Mr. Murphy goes to the victim's workplace and confronts her, and in that confrontation tears up and damages some items at her workplace. So that's the 1245 charge.
Thank you, Ms. Heisel. Mr. Wilson, any objections to that summary?
No, Your Honor.
All right, then based on the evidence presented, anything further from the defense, Mr. Wilson?
No, Your Honor.
All right. Then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Sean Padraig Murphy of this offense. The court will follow the plea agreement in this case. The court hereby convicts Mr. Murphy of continuous violence against the family, a third-degree felony, assesses his sentence at 6 years confinement in the Texas Department of Criminal Justice Institutional Division, suspends that sentence, places Mr. Murphy on 5 years community supervision, orders him to pay a $2,500 fine, $290 court cost, $895 reimbursement fees, and the court will dismiss under section 1245, cause number 2022-349, class A misdemeanor criminal mischief. Mr. Murphy, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step over with a deputy to be fingerprinted, and then you'll talk with the probation officers about the next step.
All right, thank you, sir.
You're welcome.
And Your Honor, that's all I have on the docket now. Be excused.
Yes, thank you, Mr. Wilson.
Thank you.
Donald Patterson. CR 2351. I show that we're set for bail reduction hearing today. Is that correct, Mr. Stevens?
Yes, sir, that's correct.
All right. Are you going to be calling your client for the purpose of this hearing?
Yes, sir.
All right, Mr. Patterson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, you can lower your hand. Make sure you speak up loudly and clearly so that I can hear you and so that my court reporter can take down what you have to say, okay?
Yes, sir.
Thank you, sir. Go ahead, Mr. Stevens.
Thank you. Please state your name for the record.
Donald Cameron Patterson,
Mr. Patterson, how long you been in jail now?
11 months this time, 13 months total.
Okay. You say 11 months this time. You were originally on a $10,000 bond, is that correct?
That's correct. Yes, sir.
And you were unable to make payments to your bondsman because of the COVID and you lost business, is that correct?
That's correct. Yes, sir.
So as a result, the bondsman went off your bond and that's why you're in jail now.
Yes, sir.
Okay. You're in jail on it was a $25,000 bond, I think.
That's correct.
Okay, and you obviously are unable to post that bond or you wouldn't still be here.
Yes, sir.
Do you have any cash to put toward the bond or own any property you can sell upon or mortgage?
I do not.
Okay. Now, you and I've discussed this before, and you're going to actually ask the judge for a personal bond. Is that correct?
Yes, sir.
Your case is on the trial docket, been on the trial docket probably 4 or 5 different settings now. Is that right?
That's correct. Maybe more.
Okay. And if you were to get out on either a PR bond or a reduced bond, where would you live?
We've got a house over in Park City in Highland Park in Dallas.
Okay. Do you have transportation?
Yes, sir.
You have a work truck, don't you?
Work truck. Yes, sir.
And you'd be living there with, who would you be living there with?
With my little girl, 16-year-old little girl and her mom.
Okay, and that's actually your ex, is that correct?
That's correct. Yes, sir. Yes, sir.
If,
Divorce.
okay, and you have employment, correct?
Yes, sir.
Okay, you're a contractor.
That's our construction contract, real estate consulting as well.
Okay. Do you have work that you could actually get busy doing once you get out of here?
Yeah, we have a couple projects that are already lined up. That's correct.
Okay. And you got transportation to get to and from the courthouse?
Yes, sir.
Okay. If the judge grants you a PR bond, can you, or even reduces a bond, can you promise this judge you'll make each and every court appearance?
Yes, sir, without question.
Okay. If the judge won't do a PR bond, do you think your family might could post about a $5,000 bond?
You know, I don't know what they can do. It's birthdays and holidays, money's tight, but
Okay. I'll pass the witness, Your Honor.
State, any questions for Mr. Patterson?
Just briefly, Your Honor, Mr. Patterson, I believe you stated we have a house in Park Cities. Is that your house or is that your ex-wife's house?
no, yes, ma'am, it's her family's house. That's correct.
Okay, so you don't have any ownership interest in it or anything like that?
My name's not on the deed. No, ma'am. No.
Your Honor, I'd pass the witness.
All right, and how is it that Mr. Patterson ended up back in custody after he was on bail?
Your Honor, when he was out on bail, it was during the COVID era and he had lost a job, but he couldn't, didn't have income at that time, unable to pay the bonds, and that's why the bonds went off the bond. And then as a result, it was increased to $25,000. I believe all that happened perhaps before I even got involved in the case.
Yeah, that's correct. Miss Deborah Leasy was the prior counsel.
All right, thank you. Anything further from the defense?
No.
Anything further from the state?
No, Your Honor.
All right, do you want argument at all, Mr. Stevens?
No, you joke. I just briefly make a comment that he's been in jail an awful long time. He is on the trial docket. We're just asking to either give him PR bonds and get out and go to work pending trial, or reduce the bond to around $5,000, which is an amount I think the family would.
All right, thank you, Mr. Stevens. Ms. Heisel?
Your Honor, I would just note for the record that there was a previous 1719 filed by a Springer who had him out on bond for not complying with the conditions that they had set for him. So state would oppose a PR bond if the court sees fit to grant a reduction to a cash surety amount. State's comfortable with the court's judgment on that. But given the fact that the previous time he was out on bond, he was not doing what he needed to do, state would ask the court not to grant a PR bond.
Okay, thank you, Ms. Heisel. All right, Mr. Stevens, I will take this under advisement until the conclusion of the docket today, and then I'll review the file once I'm concluded with the docket.
Thank you. Might be excused.
Yes, sir. Thank you. Appreciate it.
Good afternoon. Thank you, sir.
You're welcome. All right, Mr. Manning, I need to get one of my inmates from Smith County in, so it'll be just a All right, are you Mr. Cunningham? And you'll need to unmute that. There you go.
Yes, sir.
All right, Mr. Cunningham. My name is Judge Chris Martin, and I'm the district judge here in the 294th District Court in Van Zandt County. And Miss Lee, can you see and hear your client okay?
Yes, Your Honor.
All right, this is cause numbers F19-7, State versus Jeremy Quinn Cunningham on the felony charge of possession of controlled substance less than 1 gram, set for docket call, and also burglary of a building, state jail felony. And that's cause number CR 22-212. So Miss Lee, do you have all of the discovery in the CR case? And do you have any requests for any contested pretrial motions?
I have all the discovery and I have no request, Your Honor.
Okay. So what I would propose doing is setting these cases to be on the same track, set both of them for docket call, and then allow you and the state to tell me how we're going to resolve this case, either by plea agreement or by some type of trial.
Judge, just for the record, F 19-0007. The defendant is currently on deferred adjudication. That's a motion to adjudicate.
Okay. And that's out of the county court law, is that correct?
It was in the county court of law and has been transferred up to your court.
Okay. All right, then court will set Mr. Cunningham then for a docket call. Do you have your calendar available, Ms. Lee?
Yes, I do, Your Honor.
All right, let's look at either, how about, are you available on December 1st?
I will be available on December 1st, Your Honor.
And we also have December 15th. If one's better than the other.
December 1st is probably best for me, Your Honor, and I expect to have discussed things with Mr. Cunningham before then.
Okay, all right, so the court's going to set Mr. Cunningham for docket call on the burglary charge, and then on the MTA, we'll carry that of even date, December 1st, that'll be at 1:30.
Excellent.
All right, anything further?
Nothing from me, Your Honor.
All right.
Nothing from the state.
All right. I just want to say thank you to Smith County for arranging this this Zoom court appearance today. All right. Y'all have a good day.
Thank you, you too.
All right, Mr. Manning, are you ready?
Yes, Judge.
Who are you ready on first?
I believe my only case session is Mr. Classen, Michael Classen.
Okay. All right, Michael Wayne Classen, CR 22-173-350. I show that we are set for plea today. Is that correct?
Yes, Judge. Just to refresh the court, we're going to be dismissing, or the state is dismissing CR 22-173 as a straight dismissal. And we'll have the order dismissal tendered to the court this afternoon. The plea is going to be on CR 22-350. That's going to resolve both that case as well as DA DA reference number 2022-0726, which is an unlawful use of a criminal instrument, and DA 2022-0725, authorized use of a motor vehicle.
Okay. What are the terms of the plea?
Judge, we're going forward on information, and upon plea of guilty, punishment is going to be assessed at 8 years TDCJ institutional division with a $1,500 fine. As we said, there's going to be $1,245 on those two unfiled cases, and court cost $209 as well as reimbursement in the amount of $15. Mr. Classen has a total of 136 days credit time.
All right, Mr. Classen, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down, make sure you speak up loudly and clearly for me, okay?
Sir.
All right, your name is Michael Wayne Classen.
Yes, sir.
And Mr. Classen, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Manning, do you believe Mr. Classen to be competent to enter into this plea today?
He is, Judge.
You've explained to him his rights as they pertain to these cases?
I have.
Mr. Classen, you are charged by information with the third-degree felony offense of evading arrest or detention with a vehicle. If convicted and sentenced on that charge, the sentence would have to be within the range of a minimum of 2 years to the maximum of 10 years, and a fine, if imposed, not to exceed $10,000. And I would see that the plea agreement in this case would legally fit within that range of punishment. Is that your understanding of the plea agreement and what you want the court to approve today?
Yes, sir.
Now, you understand, Mr. Classen, that anyone who's accused of committing a felony offense has the right to have their case presented to the grand jury, and for that grand jury to determine, based on the evidence presented, whether or not, based on probability, a person is more likely to have committed an offense than not. You understand that in this case, if you're allowing the DA's office, the prosecutors for the state, to prosecute you by way of information, you would be giving up that right to have your case presented to the grand jury.
Yes, sir.
And are you doing that because that's what you want to do and you're doing it intentionally, knowingly, and voluntarily?
Yes, sir.
Has anyone told you that you have to waive your right to a grand jury or made you feel like you had to waive your right?
No, sir. I was forced.
Okay. All right. Then the court will find that Mr. Classen has been admonished as to his right to a presentment of the case to the grand jury and that he's intentionally, knowingly, and voluntarily waived that. The court will allow the state to proceed by information. So, Mr. Classen, then I've told you about the plea agreement. I've told you about the range of punishment. I've told you about your waiver of your right to the grand jury. So at this time, the only question I have left for you is, how do you plead to evading arrest or detention with a vehicle?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty to that crime?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to states one.
All right, states one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Nothing from defense.
All right. Mr. Woodwike, will you give the court the facts to support the plea?
Yes, Your Honor. On 6/11 of this year, State Highway Patrol views defendant driving without a seatbelt, gets behind the vehicle that the defendant is driving, runs the plate and discovers that it comes back to a separate vehicle that is not obviously the same make and model as the vehicle that he is driving. The officer attempts to pull the defendant over, in which he accelerates away. They engage in a pursuit that lasts for a fair amount of time until the defendant eventually enters an S curve on 3822, which is a Van Zandt County road, at an unsafe speed and basically crashes the defendant. It jumps out the driver's window, hops out, runs out into the woods, and is eventually taken into custody on scene. There's additionally, obviously, the motor vehicle is returned stolen, and there are a number of tools such as crowbars, screwdrivers, number of other tools, and the ignition is what we call punched or removed. So the vehicle has basically been hotwired.
Anything further from the defense?
Nothing from defense.
Okay. All right, then based on the evidence presented to the court finds there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement in this case. The court hereby convicts Michael Wayne Classen of evading arrest or detention with a vehicle, a third-degree felony, assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,500 fine, $290 court cost, $15 reimbursement fees. Court will grant the state's motion to dismiss and CR 22-173. The court takes into consideration under section 1245 DA 2022-276 and 725. Court awards Mr. Classen 136 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Classen, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over to be fingerprinted with the bailiff.
Mr. Manning, is the dismissal in the paperwork that you have, or do we need to produce that?
It's in there. It's just not signed at this point.
Okay, I just didn't, we'll be by to sign that. I just need to make sure it was in there.
Yep.
We don't want Mr. Classen held any longer than he needs to be.
Do we have any other attorneys that are ready?
The only other attorney, sir, is Mr. Ashmore isn't here yet.
Okay. What about Mr. Butler? Is he in the courtroom? Corey Butler?
No, sir.
He's not, okay. I've got his lawyer, Mr. Trainer, online. Ms. Heisel, while we're waiting, these protective orders for Mr. Amador, I believe that I received a signed copy of that yesterday. I don't see a need of bringing Mr. Amador up unless you want him to be served on the record in open court with that.
No, Your Honor, I believe he signed the last page indicating that he did receive service. I had that sent to the jail. His attorney went over it with him, and then I went and picked up the physical copies from the jail yesterday, so I'm comfortable.
Okay. And are we going to be pleading out Mr. Butler today with Mr. Trainer? Show us separately.
I don't believe so, Your Honor.
What about Mr. Gango and Mr. White? Will that be a plea?
Yes, sir.
Okay. I figured you were there, Mr. White, going over your paperwork. State, can you just go ahead and give me the term? I'm just going to try to make use of our time here. Can you go ahead and give me the terms of the plea, and I'll go ahead and record that so when we're ready.
Just
Or
wanna
Mr.
pull up that
Or Mr.
really-
White, if you have the paperwork there, I don't want to rush you. I'm just trying to make use of time.
Your Honor, if I may address Ms. Heisel, I got my judgment, but we're doing 30 days and the judgment was for the probation offer. If we could just have the 30-day judgment.
Okay, one second.
Ms. Heisel? Is the state dismissing state versus Corey James Butler with Mr. Trainer? Is he in-
Judge, Miss Patty emailed me about that. I asked Tonda about that because that was not my understanding, but my understanding is that he has pled in federal court and there's some chance we might be dismissing, but I don't have any information about any of those conversations. I believe Mr. Trainer was talking to Miss Curry, and I'm unaware of those discussions or any agreement, so I can't just dismiss it because
Can you track that information down though?
I will do what I can real fast, but I'm not sure. Ms. Curry is out of the office today. I'm gonna do what I can. I saw that and I'm already working on it. I just don't have it quite yet.
So I think Mr. Trainer informed Ms. Taberham that it was going to be dismissed today.
That very well may be our agreement. I just don't know about it. So let me try to see if I can track that down.
Okay.
Here's a green.
Thank you.
Oh, wait, no, let's go to. Hang on, Joe. Casey Ashmore. Before I can bring the females in. You can blow up his phone or something. He was here earlier before lunch. He said he knew he had to be here. Yeah. I texted Patty and get a hold of him.
Mr. Adams,
Yes, Your Honor.
would this be a time to bring Mr. Joslin in? I don't know if we're still waiting on other. Would this be a good time?
Can move them out here.
Yeah, we can do that, Your Honor. That's fine.
Yeah, I'm fine. I don't want to keep you waiting. I mean, if we're just doing a changeover, if we want to just put them on hold and bring your client, then yeah, we can use this time.
Then after Mr. Adams, we can have, bring the females in.
Okay, I like that. Let's do that.
Judge, we're ready.
All right, Mr. Joslin, come on up. All right, this is cause numbers CR 21-329 and 2022-75 State versus Adam Chad Joslin. Mr. Joslin, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can put your hand down, and just Mr. Joslin, make sure you speak up loudly and clearly so I can hear you, okay?
Yes, sir.
All right, Mr. Adams, will you go ahead and outline the plea for me?
Yes, Your Honor. Our agreement with the state is for Mr. Joslin to change his not guilty plea in cause number CR 21-329 to guilty. In exchange for that, the state is going to recommend a sentence of 7 years TDC, a fine of $1,000, which includes a $100 child abuse prevention fine, and the consideration under Penal Code 1245 of 2022-75, the criminal mischief charge.
All right, 290 court costs, any reimbursement fees?
$70.
$70. And what kind of credit time does Mr. Joslin have against the sentence?
432 days, Your Honor.
All right, and is this to the charge of aggravated sexual assault of a child F1 as indicted, or is it to something lesser?
It's to the first degree, Your Honor.
Okay. All right. All right, Mr. Joslin, your name is Adam Chad Joslin, is that correct?
Yes, sir.
And Mr. Joslin, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your cases and have all your legal questions answered?
Yes, sir.
Is there anything, Mr. Joslin, about the paperwork that you've read and signed today that you do not understand?
No, sir.
And Mr. Adams, do you believe Mr. Joslin to be competent to enter into this plea?
Yes, Your Honor, I do.
And you've explained to him his rights as they pertain to this case and also the specific provisions of Chapter 62.
Yes, Your Honor, that's correct.
And do you believe that he understands those?
He does, Your Honor.
All right, Mr. Joslin, you're charged by indictment with the first-degree felony offense of aggravated sexual assault of a child. That does carry a range of punishment, a minimum 5 years to a maximum 99 years or life confinement in the Texas Department of Criminal Justice. I see here that the proposed plea agreement that Mr. Adams read to the court would fit within that range of punishment. Is that your understanding of the plea agreement today as well?
Yes, sir.
All right, and Mr. Joslin, you understand that if the court accepts this plea, that you would be a registered sex offender for the rest of your life?
Yes, sir.
Okay. All right, Mr. Joslin, then understanding the plea agreement, understanding the range of punishment, this time I would ask you, how do you plead to aggravated sexual assault of a child?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this crime today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Adams, any objection to the state's evidence and stipulation?
No, Your Honor, no objection.
All right, states one is admitted and the court takes judicial notice of the defendant's judicial confession. Ms. Heisel, can you tell me about victim compliance and then go ahead and give me the facts to support the plea?
Yes, Your Honor, we are in compliance with victim notification. We don't have anything in writing back from the victim, but we did speak with her and she is supportive of the plea, and she did ask for a lifetime term on the protective order, which we filed and will need to have a hearing on next. And Judge, the facts to support this plea are that in March of 2019, the victim made an outcry at school to her school counselor that Mr. Joslin is her cousin and that he had raped her the previous summer. She said in June of 2018, when she was 13 and he was 18, he came to live with them. He began sending her nude pictures of himself, making sexual comments when the adults weren't around. Eventually, he would come into her bedroom at night and had sexual intercourse with her. She articulated that it happened a couple of times, but did not articulate a really strong time period for those acts. And I think that would conclude my summary, Your Honor.
Okay. Mr. Adams, any objection to that summary or any additions?
No, Your Honor, no objections or additions.
Okay. All right. And then, so we'll take up, I understand that there's an agreement as to the application for protective order. So we'll take that up after the conclusion of the criminal case, but I understand that that's part of the plea agreement. Is that correct, Ms. Heisel?
Yes, Your Honor.
Okay. All right, then based on the evidence presented to the court will find that there is sufficient evidence to convict Mr. Joslin of this offense. Court will follow the plea agreement based on the recommendation of the state. Court hereby convicts Adam Chad Joslin of aggravated sexual assault of a child, a first-degree felony, assesses his punishment at 7 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,000 fine, $290 court cost, $70 in reimbursement fees. The court dismisses under section 1245, cause number 2022-75 criminal mischief. And the court awards Mr. Joslin 432 days credit towards his sentence for the time that he has spent in jail on this cause. Court will find that this matter has been prosecuted under Chapter 62 of the Texas Code Criminal Procedure, and the court finds that Mr. Joslin will be required to register as a sex offender for the rest of his life. And Chapter 62, a copy, Mr. Adams, has that been provided to Mr. Joslin today?
Yes, Your Honor, I have it here, and I'm providing it to Mr. Joslin as the court watches, as we all look.
All right. So, Mr. Joslin, we're going to deliver a copy of Chapter 62 to you, which outlines your requirements as a registered sex offender. And you are hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. In just a moment, I'm going to have you fingerprinted by the bailiff. So let's take up cause number FM 22423, Ms. Heisel.
Your Honor, I believe that Mr. Adams has, with him at the jail, with Mr. Joslin, the agreed protective order. It is our understanding that Mr. Joslin is going to agree to that, which I believe would make it unnecessary for us to proceed on a factual hearing. We are asking for the protective order to remain for the life of the victim at the victim's request.
That's correct, Your Honor. It's an agreed order. Mr. Joslin and I have both signed off on it.
All right, great. Thank you. Once that's returned to the court, then the court will approve that and enter that protective order into the record. All right, Mr. Joslin, you go ahead and accompany the bailiff for fingerprinting.
Your Honor, I think that's all I have on the docket this afternoon. May I be excused?
Yes, sir. Thank you, Mr. Adams.
Thank you. Nice to see you. Mr. Watts, ready when you are.
All right, court call CR 2221, State versus Christopher Shane Gango. All right, and Mr. Wright, can you go ahead and give me the terms of the plea? I think I heard you say it was going to be a 30-day time served or something, or 30 days served.
It will be the state's going to proceed on a 0.15 Class A misdemeanor, 30 days in county jail, $3,000 fine, $270 court cost, $60 restitution, $35 reimbursement fee, and Mr. Gango has Gango has 2 days credit.
Did you say $30 reimbursement?
$35 reimbursement fee, Your Honor.
35. Okay, got it. And that's on the Class A misdemeanor. Is it DWI 1?
0.15 allegation, Your Honor.
Okay. All right, Mr. Gango, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you're going to lower your hand. Make sure you speak up a little bit louder so I can hear you and so my court reporter can take down what you have to say. Your name is Christopher Shane Gango, is that right?
Yes, sir.
And Mr. Gango, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
Yes, sir.
And you heard Mr. White read the plea agreement to the court, and that's your agreement today. Is that right?
Yes, sir.
And now the range of punishment for a reduced Class A misdemeanor driving while intoxicated is confinement, a maximum confinement of up to 365 days or 1 year in the county jail and a fine not to exceed $4,000. And I would find that this plea agreement would fit within that range of punishment. So, Mr. Gango, I would ask you at this time, how do you plead to driving while intoxicated with a blood alcohol concentration of 0.15 or greater? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. White, any objection to state's evidence?
No, sir. No objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Ms. Heisel, can you give me the facts to support the plea?
Yes, Your Honor. On July 14th of 2021, law enforcement responded to a one vehicle crash, single vehicle on FM 858. Their 911 caller states that the driver of the vehicle is leaving the scene of the crash and had basically begged him for a ride home. When the troopers arrive on scene, in that vehicle, they are able to locate a cell phone and credit card, which both have the name Chris Gango associated with them, visible on them. The constable goes to Mr. Gango's house, which I believe is nearby, and brings him back to the scene of the crash. Essentially, the witness is able to identify him. Mr. Gango denies drinking, even though the officer says he can smell alcohol on him. There are multiple empty cans in the truck. Mr. Gango makes the statement that he is going to man up and do his time, but then refuses standardized field sobriety. So the trooper goes and gets a blood warrant, and that blood draw comes back at a 0.16 BAC.
Thank you, Ms. Heisel. Anything additional from the defense?
No, sir.
All right, then based on the evidence presented to the court will find that there is sufficient evidence to convict Mr. Gango of this offense. The court will follow the plea agreement on the recommendation of the state. The court hereby convicts Christopher Shane Gango of the lesser offense of Class A misdemeanor driving while intoxicated. The court assesses the sentence at 30 days confinement in the Van Zandt County Jail, orders him to pay a $3,000 fine, $270 court cost, $60 restitution, and $35 reimbursement. And the court awards Mr. Gango 2 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Gango, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you get out of jail, then you're going to need to make arrangements to pay off the fine and court costs, restitution, reimbursement, all of those things that you owe. If you can't pay them all off at once, then you'll need to report to the courthouse and make arrangements to get on some type of payment plan so you can take care of those. Failure to do that will result in a warrant being issued for your arrest. Do you understand?
Yes, sir.
All right. Go ahead and step over with Deputy Everett to be fingerprinted, and then Deputy Everett, go ahead and take him into custody. Looks like Mr. Ashmore is here now. And Deputy Everett, do we have Mr. Ashmore's clients in the room by chance?
No, they're not. They were took him back and they're bringing all the females.
Females next. Okay. All right, Mr. Ashmore, it'll be a few minutes. We're going to have a few female inmates, I believe, for Mr. Schmidt, and then we'll bring up your clients.
Yes, Judge. Thank you. Sorry about that.
I guess that's.
You waiting on me?
Mr. Smith is talking to his clients now. He said give them 5 minutes.
Will do. You ready, Mr. Schmidt?
Yes, sir.
All right. Who would you like to go on first?
Tasha Messick.
All right, Tasha Messick, CR 2185, motion to revoke.
That's correct. Come on in. Judge, we're working with the state. I think last week I met with Mr. Woodwike. There was some confusion. It showed Jeff White still on Miss Messick's case. Got that cleared up. I think we'll probably be able to resolve this, but if we could get it set on the next contested docket, hopefully we'll have a plea ready for court at that time.
Okay, court will set Miss Messick then November 29th. And that'll be in the afternoon at 1:30.
Have a plea on Stephanie Goss.
All right. Go ahead and tell me the terms of that, Mr. Schmidt.
Judge, this is a motion to revoke. The state, upon a plea of truth, agreed to recommend that the defendant's guilt be adjudicated, that she be sentenced to 2 years of state jail, probated for 2 years, or to pay the balance of her financial obligations. And at this point, the judgment reflects $2,000 worth of fines, $960 reimbursement fees. In addition, as a condition of community supervision, she's to serve 28 days in the county jail, which she has credit for.
All right, before we go any further, Mr. Schmidt, let's go ahead and talk about Miss Goss's previous probation. How can the court be confident that this deal would be any different than the deal that I approved for her before?
Judge, when we pled the probation the first time, there was a CPS case that was attached. Miss Goss was doing fantastically through that case, dealing with some addiction issues that she'd had fairly well whipped. As a matter of fact, it's my recollection that CPS sent the DA's office a recommendation, a going recommendation, to try to resolve her case. In the interim, while on probation, Miss Goss had some life-altering events that kind of threw her off the track a little bit. I think at this point in time, she's able to get back on track and successfully complete this.
And Judge, if I may add to that, I spoke with Ms. Bryant, who was her probation officer, about placing her back on. Ms. Bryant corroborated a lot of that. She told me that she completed the Nexus program and completed several parenting classes, but again, had some events that had taken her off track. But Ms. Bryant said she would be happy to continue to supervise her, and does think that she can be successful.
Okay. All right, Ms. Goss, I'm going to have you raise your right hand so I can place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Ms. Goss, as you can see here, as I put on the screen, the state has filed a motion to adjudicate. That means to convict you and to revoke your community supervision. And in this motion, it says here that you appeared before the court on December 15th of 2020. You pled guilty to the state jail felony offense of abandoning or endangering a child. Court heard the evidence, found that there was enough evidence to convict you, but the court followed the plea agreement on that date. The court deferred a finding of guilt and placed you on community supervision for 2 years and assessed a fine. And it was during your period of community supervision that the state filed this motion to adjudicate and included in there 5 separate allegations. Have you had enough time to go over this motion to adjudicate with your attorney, Mr. Schmidt?
Yes.
Are you pleased with his representation that he's given you?
Yes.
And do you feel like you've had enough time to talk with him about the motion and have all of your legal questions answered?
Yes.
Mr. Schmidt, do you believe Ms. Goss to be competent today to enter into this plea agreement?
I do.
And you've explained to her the rights as they pertain to this motion to adjudicate?
I have.
All right, Miss, and does your client intend to plead true to all 5 counts?
We do, Judge. We waive formal reading of the motion, and it's her intent to plead true to all 5.
All right, thank you, sir. Ms. Goss, then at this time, I'm going to ask you, how do you plead to counts 1, 2, 3, 4, and 5 as contained in the state's motion? Are those allegations true or not true?
All true.
And are you telling me that each one of those allegations is true because in fact it is true? You're not just saying that so you can get another chance at probation?
No, they're all true.
Okay. All right. The court will accept the defendant's plea of true. Mr. Schmidt, any objection to the defendant's waiver of rights and plea of true as State's Exhibit A?
No objection.
All right. State's Exhibit A is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, sir.
All right, then Ms. Goss, let me hear from you. I've heard from Mr. Schmidt. I've heard from Ms. Heisel. I want to hear from you now.
I was doing really good and my husband filed for divorce and it devastated me. I kind of quit caring about life. I didn't want to live, period. And I was since then realized like the only way I'm gonna be able to see my daughter again or have anything to do with my daughter is if I don't, I have to start caring again. I just recently had gotten a job and started getting back on my feet. I did the rehab for CPS and was doing the parenting classes. I was doing everything that they wanted so I can see my daughter again. And it's my daughter's my life force. She's the reason I'm going. And the only way is if I stay out of jail and I do what's right.
Okay. Well, I don't want your daughter to be your life force. I want your daughter to be somebody that you care about and you're motivated to do things for, but you understand that your happiness cannot be based on one person. You understand that?
Oh, no. I'm the only reason I can be happy, but my daughter's no reason to fight, to be happy, to be a better person.
Okay. All right. Well, I'm gonna in just a moment, I'm gonna follow the plea agreement here and I'm gonna give you the second opportunity that you want. Just know that you're starting to run out of those opportunities because this can't be a continuing revolving door of on probation and in jail and back on probation. It just doesn't work that way. Okay. All right. The court will find that based on the evidence that Ms. Goss has violated the terms and conditions of her community supervision, court will follow the plea agreement in this case. Court finds each count to be true. Court will adjudicate the guilt of Stephanie Lynn Goss for abandoning or endangering a child. State jail felony. The court will assess her sentence today at 2 years confinement in the state jail division of TDC. After 2 years, the court will suspend that sentence, place her on 2 years community supervision, order her to pay the balance of her financial obligations, plus new court costs and attorney fees. Court will order her to serve 28 days in jail as a condition of her community supervision, and the court will award her 28 days credit for the time that she has spent in jail on this cause. Ms. Goss, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. He'll step over with the deputy to be fingerprinted, and then the probation officers will give you more information. Who do you want next, sir?
Brittany Hamilton.
Ms. Hamilton?
Yes, sir.
All right, this is CR 2170, State versus Brittany Marlene Hamilton. Show that we're set on a bail reduction. Is that correct?
That's correct, Judge. Motion for bail reduction.
All right, are you going to call Miss Hamilton today?
I will, Judge.
All right, Miss Hamilton, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Just make sure you speak up loudly and clearly for me. Go ahead, Mr. Schmidt.
Thank you. State your name for the record.
Brittany Hamilton.
And Brittany, you're charged with possession of a controlled substance, penalty group 1 less than a gram. Is that correct?
Yes.
State jail felony. And we announced ready for trial some time ago. It's been several months, has it not?
Yeah.
Do you recall when we announced ready for trial? It's about 6 months ago, wasn't it?
Hey, Mr. Schmidt, hang on just a moment. I'm picking up some other conversations in the jail. We're having a hard time hearing.
So we've been on the trial docket for probably about 6 months, if I were to guess. Does that sound right?
Yes.
On August 15th, you were set to come to the courthouse and sign a reset notice for the jury selection docket. Is that correct?
Yes, sir.
And on that date, you were late to the courthouse. Is that correct?
Yes.
And when you ultimately made it to the courthouse, the court had revoked your bond. Is that right?
Yes, sir.
Now, why were you late to court that day?
The radiator has been messing up on us. It had a leak and that's the reason why I was late.
Okay, and so now you have a co-defendant, his name is Charles Howard, is that
Yes.
correct? And the two of you are also in a relationship, is that?
Right.
So you relied on Mr. Howard for transportation, and he was basically coming to reset with you, is that right?
Yes,
And he was also arrested for
Right.
bond revocation.
yes, because he was late.
And did he bond out on the
Yes,
already? So he's already back out. How long has he been out?
about a month.
About a month. But the vehicle issues that you had, basically were the reason for your tardiness.
Mhm.
But you did show up to court that day.
Yes,
Now, I think that we've had some issues with,
being late.
being late on your reset dates. Can you tell the court what the problem was, that prevented the two of you from getting to the courthouse on time?
It was just the truck being the problem.
Okay, so basically you have transportation issues and the two of you were trying to get here as quickly as you could. And did you have a lot of breakdowns with that vehicle?
Yeah, it's just the radiator, and then we also had problems with something else. I'm not really for sure what the problem was.
Okay, but at this point, your bond is set at $40,000, is that right?
Yes,
Are you able to make that?
no,
And have you made any efforts or tried through family to raise the bond?
yes,
And that's been unsuccessful, is that correct?
right,
Now, obviously, you know, when the court sets your hearing or your reset date at 9 AM, the court expects you to be there at 9.
Right.
And ultimately, that's being late is why you're sitting in jail right now. You understand that?
yes,
If the judges would agree to your bond request and you're out, you'll have to continue to come once a month at least to set your,
yes, I can do that, and I won't be late. I have a new new way of transportation.
so you have an ability to get here on time and reliable transportation.
Yes,
And are you telling the court that if the judge were to grant your motion, that you would not be late again?
I will not be late again. I would have to sit here for 71 days. I am not.
And I know we're talking about you being tardy to court. Have you failed to show up to court on a reset
No.
date?
I've only been late.
So you've been late a lot, but you've made it. Okay. Are you asking the court to grant you a PR bond pending your trial setting in this case?
I would love that PR bond
Okay.
because I take care of somebody that's disabled.
Who do you take care of?
It's Faith Moore. And I have documentation from the Epilepsy Foundation that states from her doctor that I'm her caregiver and that that she is currently unable to work.
Okay, so you're anxious to get back to tending to her as well.
Yes.
Okay. I'll pass the witness, Judge.
State, you have any questions?
Briefly, Your Honor. Ms. Hamilton, so
Yes.
your significant other, whatever your relationship is, he was arrested at the same time as you were, is that correct?
Yes.
And he bonded out,
hmm
and he didn't bond you out? He can't raise funds to bond you out?
I mean, we were behind. No,
You talked about how you have a new form of transportation. What is that and who owns it?
it's a scooter and I own it.
Okay, so it's like a motorized scooter of some variety?
Yes.
Judge, I have no further questions.
Anything further, Mr. Schmidt?
Nothing further, Judge. We rest.
Ms. Hamilton, why didn't you pick up the phone and call the court and tell us that you're going to be late?
I was under the impression that if we were there before 5, but because we were late a couple times, and they said as long as we were there before 5, so I didn't think, I don't know, I neglected that part of it, and I won't do it again.
It wasn't like you were just showing up at 9:05 or 8:35.
Right.
Sometimes it was between 4:30 and 5 p.m.
Yes, sir, but I know better now, and I won't do it again. I've been sitting here long enough. I've learned my lesson. I promise.
All right, court will take it under advisement, Mr. Schmidt, and I'll issue an order at the conclusion of the docket.
Thank you, Judge.
And I'll notify you in the state.
All right, thank you.
Okay.
that all you have, Mr. Schmidt?
I believe that's it, Judge.
Mr. Woodwike, were you able to get any information on Mr. Butler?
Judge, Ms. Curry is currently at a medical appointment, so she's kind of in and out. She asked me what he got from his federal plea, which is, my understanding, is the basis. And I have not heard back from her, so I don't know. What I would suggest, I don't know where Mr. Trainer is.
Well,
but if we-
he's in the waiting room, so that's what he's been here since 1:30. So let me bring him in and we'll put him on the record and cut him loose. I just didn't know if you were going to be dismissing today. That's the impression he had given Ms. Taberham.
Judge, and I think that may be the agreement. I just don't think that was ever communicated to myself or Ms. Heisel, so I don't feel comfortable just dismissing based on we think that was the agreement. I think that is the agreement, but I don't know that. So I need to confirm if we need to reset till Thursday or till.
Yeah, well, let's wait till we'll wait till Mr. Trainer gets in here and he may have something. Well, let's see, where did he go? Brought him in and then it kicked him out. Either way, Mr. Butler's not here, is he? There he is. Let's try again.
That would be a question for Deputy Everett, because I don't know if he's in our custody or not.
Good afternoon, Mr. Trainer. Can you see and hear me okay?
Yes, sir. How are you doing?
Oh, I'm doing fine. Hope you're doing well also. This is cause number CR 2262, State versus Corey James Butler. I had on my note, a note on my docket that said we were going to be set for plea. My court coordinator tells me that Mr. Trainer, you indicated that there was supposed to be some kind of dismissal due to a federal plea. I've been discussing it a little bit with the assistant DAs here, trying to find out some more information about that. What can you tell me what the subject of the conversations you're having with Ms. Curry about the potential disposition of this case?
Yeah, they asked me to go ahead and get the plea paperwork from Corey and to show that he was signing on a deal with them, and yeah, they said that if he was going to be picked up by the feds and have that case there, that they would dismiss it. We actually last discussion of that was there in court.
Is that with Ms. Curry?
I do not remember, sir. I didn't catch her name that I was talking to there.
Okay. And so have you gotten the federal plea paperwork and provided that to the state?
Unfortunately, I have not, Your Honor. They've not provided a copy of it to my client, and my client is trying to get it from his attorney. I was anticipating having it over here today, and I have not received it.
Okay. All right. Well, we'll reset Mr. Butler then for a status. Are you available on December 1st or 13th? Or 15th?
Let me check real quick, Your Honor. And are all those afternoon times?
Yes. We could probably put it on a morning, but I usually put inmates on the afternoon, but I'm not sure I'll ever see your inmate.
And you said either the
December 1st, I've got December 1st, 13th or 15th.
13th.
And I put
December,
it in,
yeah, the 13th would be perfect, Your Honor.
13th. And if you want to do it in the morning, we can do it in the morning.
No, the afternoon is great.
Okay. All right.
Hey, sorry, Judge. I was just going to say, Mr. Trainer, if you can get us the documentation prior to that, we can probably move to dismiss this without an additional appearance on you, because I know he's in federal custody. So I don't know that there would necessarily be the necessity of a hearing if we can get this resolved just by paper beforehand. We're willing to do that. We just don't I don't know enough to do that right now.
I understand. Unfortunately, I'm not his counsel on that one, so I'll be shaking down whoever I need to get that paperwork for you. Can I have an email that's going to be best to send it on over to?
It's I have your email. Let me send you an email. That'll be easier to do than trying to spell my last name. It's on the Zoom, but I'll just send you an email here in just a few minutes so you can have it.
All right, wonderful. I do appreciate it. If you'll just use Corey Butler's name in there, that way I can pull it up and we'll get that right on over to you.
Yes, sir.
All right. Hey, thanks a lot.
All right. Thank you, Mr. Trainer. We'll see you back on December 13th.
All right. Or hopefully we'll have it taken care of before then. Thank you, Your Honor.
Yes, sir.
All right. Bye now.
Let's see. I got Dustin Hall with Mr. Weiner. And Mr. Weiner is going to appear via Zoom.
He's in the courtroom, Your Honor.
Oh, he is?
Well, Mr. Hall is.
No, I'm looking for Mr. Weiner.
Yeah, he's not here.
And I can't remember. Maybe he told me that he had something in another court and it may be late. I'm not sure. Are you ready with Mr. Ashmore?
Both of them in the courtroom, Your Honor.
Okay, yes. Go ahead and bring him up. Mr. Ashmore's here.
You'll start with Mr. Hart or Spriggs?
We'll just go down the docket. We'll start with Mr. Hart. Jamie Floyd Hart, CR 22146. And
Good afternoon, Judge.
Good afternoon. Mr. Hart set for pretrial.
He's set for pretrial, Judge. We have received the initial discovery from the state and an initial offer of 15. I've been conferring with Mr. Hart and the state about other agreements we may reach. And, you know, right now we don't expect that there are going to be any forgive the train, Your Honor. We don't expect there are going to be any contested pretrial hearings, and we've put forth none at this time. You know, it's summarized, Judge. We're asking the court for an additional reset. I've been asked by Ms. Heisel to provide anything mitigating that I can get. I think I'm going to need a minute to get that from my client. I do have some things that I'd like the state to consider before we either reach a final plea or agree we can't reach a final plea. But right now, that's my respectful request. And we'd ask the court to, set that a couple weeks out so I can get some information, some of which is in my client's or his family's possession, and some of which I believe is part of his medical records. So I'll probably need a HIPAA to get the release of some of that so I can give it to Ms. Heisel.
Okay. All right. The court will set Mr. Hart then for docket call. Are you available on December 1st or 13th or 15th?
I'm looking at my calendar right now, Judge. I've got a contested hearing in the afternoon on the 1st, so my request would be 13 or 15, either of which looks clear.
Okay, let's go December 15th.
Very well. Thank you, Judge.
And that'll be for docket call at 1:30.
Yes, Judge.
You know, Mr. Hart?
Yes, Dylan, Mr. Hart. Thank you, sir. All right. State versus Casey Lynn Spriggs, CR 21371. Pretrial.
Sorry, Judge, was trying to plug that calendar date in. Judge, we have some evidentiary matters that are filed and before the court, and we've also been in negotiations with the prosecutor on this case. And I'll just say that they're ongoing. I've spoke to Ms. Curry within the last 7 days, and we may be closer to a resolution than perhaps we ever were. My request to the court is that Mr. Spriggs be set on the evidentiary docket in the month of November, which is my understanding, the next available setting. And that at that time, we'll take up those matters.
Okay. All right, court will set Mr. Spriggs then for evidentiary hearing on 11/29, November 29th, and that'll be at 1:30.
Judge, if I could just have a moment to check that calendar, please.
Mhm.
Well, we'll make it work. I don't want to delay the court's business.
Yes, sir.
That's all, Mr. Spriggs. Thank you, sir.
Thank you, Casey. Thank you, Judge.
We also have Mr. Manis on the docket today. I understand that Mr.
Yes, Judge.
is hospitalized, undergoing competency restoration. Is that correct, Mr. Abraham? So let's just set him for a status. Well, let me ask Mr. Abraham, do we get any updates from Terrell State Hospital or wherever he's at? He's in Montgomery County. Okay. All right. So let's just set this for a status in January. And then if you receive any information, Mr. Ashmore, you can feel free to share it with the court before then or after. But let's see here. Let's just set, I just don't want him to fall off the docket.
Right. Yes, Judge, just so you know, a few weeks ago, Deputy McLeish and I went to check on him and were informed at that time that he'd been finally transferred to a hospital. I understand that the court took whatever efforts it could to fast track that. I appreciate that very much. And I didn't know he was in Livingston, but I knew that he was no longer in custody in the Van Zandt County Jail.
All right, we'll just set him for status. If you have your calendar, I don't expect this to be a quick turnaround. So how about let's look towards the end of February, perhaps February 21st.
I'm looking now, Judge. On my calendar now, Judge.
All right, court will set then Mr. Manis for status competency on February 21st, 1:30. All right, is that all you have, Mr. Ashmore?
It is, Judge. Thank you so much.
Thanks, sir. Appreciate you. Have a good day.
Okay. Bye-bye.
And so, Mr. Hall, all right. Can one of you reach out to Mr. Weiner and determine if he's going to be able to appear via Zoom? Do you all have his contact info?
Judge, I will reach out to him. My only question is, this is a motion to adjudicate, and I don't know if.
Well, let me ask, Mr. Hall, are you still represented by Mr. Weiner, or was he your attorney on your case before you got probation?
Yes, sir. He was my attorney on the case before I got probation.
Okay, so he's not representing you now?
No, sir.
Okay, well, that makes sense why he's not here. That just, we'll have to fix this in our system. Remind me, were you were seeking time to hire an attorney to represent you, is that right?
No, sir. I've just been kind of going off my probation officer. I went into the report and they said I had a warrant because I got arrested in Henderson County 3 or 4 weeks into my probation on prior warrants I had. So I went in to report, she said that there was a warrant and they brought me over here. I've really just been kind of blind to what's going on. I've been waiting to see you and see what I haven't talked to Weiner or my probation officers since they let me up.
All right, give me a second. We'll look at it together. All right, Mr. Looks like there was a motion to adjudicate filed on August 3rd. I'm going to show you what they're alleging. So it seems to be a single count of a driving while license suspended July 16th of 2022. So as it stands right here, the question that you'll have to answer is, are you going to hire an attorney to represent you on this case? Do you believe that you're indigent? Will you be requesting court-appointed attorney? Represent yourself? Kind of what do you want to do?
This is for the, I mean, I guess I just, court appointed attorney, I'm guessing, yes, sir.
Do you believe that you're indigent, like you're poor to the level that you couldn't afford an attorney?
Being in here, yes, sir. I have a job and everything waiting on me out there, and I just can't, I mean, in here, I'm not able to pay my fees or afford an attorney or anything at the moment.
Outside of the jail, do you own any property, cars, cash and accounts, anything that you can sell, assets?
No, sir, I mean,
All right, then what you'll need to do, Mr. Hall, is you'll need to fill out the request for court-appointed attorney, and you'll need to send it over for my coordinator to review and bring it to my attention. We'll review it, and if you meet the requirements for court-appointed counsel, then we'll appoint you one, okay? If not, then we'll notify you that you don't meet the criteria, and then you would have to hire an attorney or represent yourself, okay?
yes, sir.
So go ahead and ask the jail for the paperwork. They'll give that to you, get it filled out, and they'll get it sent over to us. What I'll do is I'm going to reset you for here just a couple of weeks. I'm not going to leave you in there very long for us to kind of go over this. I'm going to set you for Tuesday, November 8th. But I need you to get that paperwork in ASAP. Okay.
Okay, yes, sir, I'll do it right now. Judge, I have the paperwork right here.
Okay, good. Go ahead and give him that and have him fill it out, and then we'll get it transmitted over. All right. And I think that concludes our docket for the day. Is that correct?
Yes, sir, we're done.
Yes, Judge, that's all I show.
All right. Thank you, Ms. Heisel. Thank you, Mr. Woodwhite.
Thank you, Judge.
You're very welcome. Thank you, Deputy Everett.
Thank you.